Today I'm going to look at the decision of the Supreme Court of the United States in Trump and the United States. In that case, it was held that former presidents have immunity from criminal prosecution for conduct carried out whilst they are president, if the conduct was an exercise of their presidential powers, official duties, so carrying out official duties, and somehow an exercise of these powers and these actions done in consequence involve criminality, they are immune from prosecution. A part of the absolute immunity deals with those actions that are done by presidents that fall within their conclusive and presumptive constitutional authority. So the absolute immunity is only for those actions that fall within their conclusive and presumptive constitutional authority. The more general immunity, the presumptive immunity, so not absolute, but the presumptive immunity deals with all other public acts, official acts. So official acts done in that role, in that capacity as President of the United States, in that executive office of President of the United States. And we look at the norms and what's really generally the role of president and what goes on in there. It's not all laid out in law. So making an evaluation of this does require looking at the scope of that office and what officially the powers and role and actions are of the president. The decision is not controversial from the common law jurisprudence perspective because most common law countries have the same immunity that has been recognized by the majority in Trump and the United States. They have immunity for government employees and government officials who are exercising official powers, carrying out official activities. They are the same, the common law countries generally are the same as what the majority has held in Trump and the United States, in that there is no immunity from criminal prosecution for private acts. Now, what is picked up on by Associate Justice Sotomayor in her dissenting judgment is the distinction between an English king and a United States president. And that same distinction applies in the UK to our Prime Minister or any government official and the King. The King is a rare exception, but generally government employees, where the real power is in the United Kingdom, the real exercise of power and functions and public functions is no different to the United States. And the president is just another government official in the United States. So it's quite different to a king. So Associate Justice Sotomayor picks up on this point and says, well, and makes reference and says it'd be not appropriate to give a US president the sort of immunity that an English king has. And that's correct. And the majority in Trump and the United States have not done that. They have said that any private wrongs will be dealt with in the criminal courts. Official acts, there's this state immunity, what we call crown immunity in the United Kingdom. The difference with the king in the United Kingdom is both official acts have immunity if they involve criminality as well as private acts. So take the example if the king decides to give out knighthood for a large payment, that would be a criminal offence contrary to the Honours and Prevention of Abuses Act 1925. However, and an exercise of official power, but there would be absolute immunity for the king in those circumstances. Let's say, let's contrast, let's think back to Henry VIII. Let's say someone brings in not nice food and the king slices their head off with a sword. That would be murder. Again, the king, for that personal wrong, would have absolute immunity against criminal prosecution. But no government official in the UK would have that. Private acts are dealt with as criminal, and they'd be prosecuted and tried the normal way. The fact they did it whilst at work would be of no relevance. So the exercise of these public powers is what's important. These the official power, the official acts and duties is what's going to be the source of any criminality. So that's not too different to the rest of the common law world. We can leave aside the exception for a king, because let's face it, if the king did commit either public or private wrong, the media pressure would be so strong that there'd be an abdication. So it just wouldn't happen. We don't really need to worry about in that respect. Whereas with presidents, prime ministers, and ministers, and departments, government departments like the Ministry of Justice, we do give them this immunity. It's controversial, again, as pointed out by Justice Sotomayor in her dissenting judgment, because of rule of law and the idea that everyone should be accountable under the law. This has been particularly problematic in the United Kingdom as far as the Ministry of Defence has been concerned, because it's one of those areas where you do carry out certain activities, and if they're not carried out in a very careful way, a non-grossly negligent way, they can result in deaths. And there's been, in non-combat activities, or just normal standard military training exercise, been over 100 deaths since 2016. And it's been reported quite a few of these have involved gross negligence, the sort of gross negligence that would normally result in a manslaughter conviction. So there's been this issue of should they have Crown immunity in those circumstances. Scotland, since 2010, has moved away from the idea of a presumption of Crown immunity or state immunity towards a more transparent, accountable approach. The majority judgment, however, delivered by Chief Justice Roberts, is not unconvincing. It's quite convincing, and if we look around the common law world, it's not sort of unusual. It's not sitting out on its own as controversial. If we look at the states in the US and the immunities given to governors, again, this is supportive of this whole idea. If we take the sort of Ronald Dawkins approach of a broader moral reading of the Constitution, if there's a very wide norm that this is done this way, I won't go into the value of giving some sort of state immunity in this short commentary, because there's equal arguments against, and I think the rule of law probably trumps those, the case for immunity. But there is a pretty wide normative base for taking the approach that Chief Justice Roberts and the majority have taken in the case. The strong point, if we're looking at this sort of Dawkinsian moral reading of the Constitution, the strong support for the dissenting judgment of Sotomayor, particularly Sotomayor, is the rule of law argument. That is such a fundamental and strong consideration that it does really provide a powerful case, given the lack of textual support for this immunity, for not having it. The lack of textual support is not a strong argument in favor of not having immunity for the exercise of presidential powers, because if we really to argue that strongly, then we'd have a problem with a case like Roe and Wade, which Associate Justice Sotomayor was in the dissenting judgment in that case, and rightly said that Roe and Wade shouldn't be overruled. But if we again look at the moral reading of the Constitution and the history and the time that precedent stood for, and following again with the idea of autonomy as a right in Lawrence and Texas, not really about privacy, it's about autonomy, the freedom to do what you like if it's not harming others, and the state can't find a legitimate reason for curbing your freedom, then we can't really just toss a coin over with this case because it's involving Donald Trump and say, well, we need it all expressly put in text. Because if we look carefully at the text supporting Roe and Wade, overruled now in Dobbs, it's not saying much. If we really looked at it in a very technical way. It says not much, but you have a procedural protection in that you should have due process, which is about how you would run a trial, nothing else. So I don't think that's the powerful argument. I think the powerful argument is the idea of rule of law in this day and age, 2024, and that it really is important that it be adopted if there's any grey area or any scope for bringing it in. But equally the case, it was a grey enough area, it could be interpreted either way, and it's gone to the way of immunity. And I'm all for abolishing such an immunity in the United Kingdom as well. I don't see that it's defensible in any sort of normative sense, but if we're looking at legal interpretation, it's plausible, the majority judgment. The other points that were made in the dissent was a reference to Nixon and the fact he was pardoned by Ford. But if we look at Nixon's conduct, it was clearly obstruction of justice, clearly a criminal act, and it's not needed as a means for carrying out some sort of presidential power. The Trump case differs in that, to the extent that he put pressure on the Department of Justice to try and get them to investigate so-called electoral fraud, there clearly was no fraud, and it was an abuse of his powers, misconduct in public office, a common law offence which has been charged and led to convictions in many states in the United States. I don't know of a federal, it being applied in the federal context. There is abuse of office as a misdemeanor in the federal code of regulations, but it's not generally a precedent that I can think of where misconduct in public office applied to a senior official in Washington. So in a criminal sense, in that it's a result in a conviction. So this is again the difficulty, because he put pressure, he abused his position, he abused the office of president, the powers and the official capacity he had to try and overturn this election result. And when we're prosecuting the common law offence of misconduct in public office, it has to be a misuse of the public power. That's what's required for the conviction. It can't be some private wrongdoing whilst in your public office. It has to be some misuse of that public power, that official power. Trump certainly did that, but the problem with this new immunity that's been provided for is it states the exact same thing. If it's an official act, doesn't matter if it's an abuse of that official power and it's a misconduct, as long as it's a use of that public power and exercise of that public power, there's immunity. So in proper or an abuse of the power, the official power is going to lead to immunity. So there's no doubt about that. So you would then need to look at, was he involved in obstruction of justice, something a bit more technical in a criminal sense, like we saw with Nixon requesting a pardon. The thing that might have stuck would be the incitement of violence on the Capitol. But again, he lacked the mens rea from all reports. It was foreseeable, subjectively foreseeable, that violence would follow his speech, that it was imminent or likely to occur. The subjective foresight's not sufficient mens rea for the incitement offence in the federal law of the United States. It requires direct intention. He'd need to have intended and had it as his purpose that those individuals carry out the violence they did carry out, the violence and criminal damage, and that's where it falls. So going forward, the implications is that this will go back to the district judge in the District of Columbia, and she will have to try to determine which acts were official acts that result in criminality, and they're going to be put aside because he's got immunity. And is there anything left? Is there some other conduct that they could say, well, really was an exercise of presidential powers, not even remotely connected to it, that was just straightforward personal misconduct, because that's where he's not going to have any immunity. Thank you.